How to protect your stuff in 3 easy steps. Welcome. My name is Paula Collins, and I'm an attorney licensed in the states of New York, New Jersey, and Missouri. You've got my contact information here. Please reach out to me for questions, follow up, anything else that you might want to know. You'll notice here that I have a logo for my law firm, but also for Lawyers with Purpose. I'll mention that network of really, really important mentors as we go through the webinar today. So, a couple of things. I can make some promises to you. One, we're going to have a lot of fun. Oh, time will go by quickly, and you're going to learn a lot. Now, if I keep those 3 promises, please reach out to me via phone or via email. There's my phone number, there's my email. Now, a little bit about me. You might be wondering, what is it about this attorney that has her so jazzed about estate planning? Well, I'll tell you. Right here in the middle is a picture of my mom. This is a picture of my mom the year that my dad passed away. There's a picture of me on the left and a picture on the right around that same time, a little bit before my dad passed, a little bit after. You can see that I was really into music. That made a significant impact on me. It really did drive home to me the importance of planning. And so as an attorney, I bring that experience and that passion when I work with other families to protect assets and to plan for the future. Most people who come to a webinar want to know, can I protect my stuff from taxes, long-term care, family? How do I do that? What is a power of attorney, a living will, and a healthcare proxy? And what's the difference? Which do I need? What's a trust? What's the difference between a revocable trust and an irrevocable trust? And how can I avoid probate? Do I really need to? Can I or should I give up my stuff to the kids, to others? If I give up my stuff, will it take 60 months to protect it from Medicaid and other kinds of situations? Can I qualify for Medicaid if I have a pension or other form of income? Do I have to go broke to qualify for Medicaid? And are my IRAs safe? Do I need a special plan for them? How can I plan for my disabled beneficiaries? Anything else that you want to know, please reach out. I'll be glad to address them with you. So, 3 steps to plan and protect your estate. Know the rules, know your predators, and know your options. Generally in this workshop, we want to get to know, are you all set? Do you have the things in your plan that you need to protect your own healthcare needs and the needs of the people that you'll leave behind? And if you are all set, that's great. If you're not, hopefully you'll hear about something that you can ask me about later. Now, in truth, Washington University did a study. They found that only 4% of all estate plans really accomplished what the grantors intended. So that leaves 96% of all estate plans that leave out some critical element that the grantor really intended it to do, but it did not. We don't want that to happen to you. The first step, know the rules. Well, the government has rules when you're alive and after your death. First of all, it's very simple when you're alive. The government says that somebody has got to be able to act on your behalf. Now, when you're alive and fully cognizant, that's you. But suppose you have a stroke or a fall. Suppose you get COVID and go on a ventilator and then off to rehab for 2 months. Somebody's got to be able to act for you. Either you've done the planning and designated somebody in advance, or the government will appoint somebody to act in that capacity. Once you're horizontal, game over. In other words, once you're disabled or not cognizant, or worse, once you're dead, you won't be able to make that kind of a plan. Make your plan while you're vertical, while you're sitting up, while you're standing up, and you're able to make these decisions. So if you've appointed someone, you've appointed a power of attorney, and many times you've also appointed a healthcare proxy. Most of you have already done this in your plan, but let's review it. We'll start by defining what we mean by a power of attorney. A power of attorney is a document that grants legal authority to someone else to make legal and financial decisions on your behalf. A power of attorney is valid upon your signature, and it's invalidated when you revoke it, or when you die. So if you've already signed somebody up to be your power of attorney, if you've already said, please, will you be my power of attorney, signed here, it's already in place. It's just a matter of them taking that action. Likewise, if you've already consented to be someone else's power of attorney, you've already got that authority. It only dies when it's specifically revoked or when that person dies. So if your power of attorney will die when you die. Some people think that the person who has power of attorney can hear of your death, rush out, drain the bank account, start giving away all of the cash to creditors or to beneficiaries, hiding stuff so that they can hide it from taxes or from the court, the probate court. It doesn't work that way. The law is very specific, and it says that that would be an invalid transfer at death. Any sale of property or transfer of bank accounts that occurs after your death by your power of attorney is not valid. Now, we'll shift gears. A healthcare proxy, on the other hand, that's a document that grants legal authority to someone to make healthcare decisions for you. Now, I noticed when I turned 50 that doctors started having me complete one. So, I would show up and they would say, oh, you're here for your 2:00 appointment. Please fill out these forms. So how neat is that? It's like one-stop shopping. I get my blood pressure meds refilled and I get my legal planning done, all of my estate planning. Doesn't really work that way. Let me tell you the downside of that. Suppose I said, right after this, email me your symptoms. I will Google them and I will reach out to your pharmacy. They'll get all your prescriptions together and then they'll let you know when it's time to come pick them up. Silly, isn't it? I'm a lawyer. I'm not supposed to make medical choices for you. Similarly, when you go to the doctor's office, that should not be the full extent of your estate planning. There needs to be a lot more that goes into it. Hilarious example, right? Crazy, but I hope you get the point. We need an overarching plan. So let's take it all a step further. A healthcare proxy produces the authority and designates the agent. A living will really describes what it is that you want. Have you ever seen the form that says, do you want artificial feeding? Initial here. Do you want artificial resuscitation? Initial here. But let's go a lot further into writing your rule book than just that, just those two questions. I advise clients to go really very deep. Let us know, let the care team that's working on your behalf know, what kind of music do you like to listen to? What kind of books do you want played for you on audiobook? Do you want to sit in the window in the morning, or do you want to watch the sunset in the afternoon? Do you enjoy opera? Do you enjoy jazz? Do you enjoy rap? All of these things will still be important to you, even if you're incapacitated, because let's face it, you'll be the same person. It's just you'll be relying on your care team to take care of you. And so you will have needed to have communicated all of those things to that care team beforehand. So what do you do if you don't have a healthcare proxy or a living will? I say, don't worry, the government has your back. And that's true. It's very simple. The government has a guardianship proceeding. It's a full-blown trial. The first thing that happens if you become incapacitated, your loved ones have to bring up a legal proceeding in court. They hire a lawyer to make sure you're really incompetent. You become known as an AIP. That's an alleged incompetent person. For the trial, 2 doctors have to testify that you are incompetent. And by now you're probably asking, now, wait a second, because I forgot to mention the court hires a lawyer also. So you've got a lawyer, the court has a lawyer, 2 doctors. Who's paying for it all? You are, because it's going to come out of your estate, either beforehand when you've made a plan for it, or usually it comes out at the end when the estate is being settled. But that means that your relatives are having to put forth that money up front and then wait to get reimbursed. If your relatives are already short on cash, you don't want to burden them with that. So now, how about this? Suppose you have a plan and a relative contests the plan. a relative pops up and says, oh, his spouse is going to spend all his money. I don't really agree with it. Or I don't agree with the facility they've got her in. It's just not right. I think I'm going to go hire a lawyer and find out how I can help. And you better believe that happens every single day. Family members most often don't argue about money while their loved one is alive. Really, most often what they argue about is care. So make a plan, communicate the plan. Now, while I'm talking about healthcare proxy, let's talk about another disturbing thing about the law. We might as well call that healthcare proxy a God proxy. Here's why. Imagine that you're walking down the street, going to meet your friend for lunch. You look down at your phone, you trip, you're flat out on the pavement, unconscious. Ambulance comes by, scoops you up, takes you to the hospital, and they say, you know, it's looking really, really bad. We don't know if she's going to come out of this. Should we try to save her? And your healthcare proxy is alarmed and starts acting not according to what you had expressed in your documents, but according to their own emotional radar. They say, what do you mean? Should we save her? Of course, save her. I was supposed to have lunch with her today. She's not supposed to die today. Plug her in. And just like that, all of the planning that you did in that regular set of documents can be undone. And in that case, if in 2 weeks or 2 months or 2 years, somebody else thinks, wow, we really need to end this, we need to pull the plug, you will be right back to where you started, where your family members will have to sue in order to have that right to do that. So what we want to do in your documents is plan for that moment when a healthcare agent might act out of emotion, and make a plan so that your document has a fail safe. Actually, what my lawyers with purpose lawyers call it is having a second bite at the apple. So we have that moment. If the healthcare agent should act out of emotion, we want to build it in so that your plan has another safety net, and you get to decide when that would be. 2 weeks, 2 months, 2 years, when if it becomes obvious that your prognosis is bleak, that we could go on and, you know, act on your wishes, pull the plug. Here's the rest of the story. When you're picking your healthcare proxy, pick somebody who can make those difficult decisions under pressure. Now, some lawyer humor here. Some of my attorney friends say, well, that's easy. Just pick the relative who hates you the most. They won't be haunted by this choice later on. That might be a little bit extreme, but 2 things about this conversation. Pick somebody who can act not out of emotion, but stay true to your documents, and have your documents have a built-in fail-safe. Have your documents have that built-in second bite at the apple, and communicate your plan. The most kind and loving thing you can do for your relatives is to put your voice into your own plan and then communicate it. So those are the rules. Those are the rules when you're alive. Now, when you die, something happens. The law says that we have to go through certain procedures. You have a will, and of course, we've all seen on television the very dramatic reading of the will, and the long lost relative inherits millions, and there's a the next day they move into the mansion, right? Wrong. It never works that way. Here's why. The will merely informs the court of what your wishes are, but the very best constructed will still has to go through probate. Even if you've set up everything so that you have beneficiaries on your accounts, or you're thinking that things will just pass through very uneventfully, you better believe that there's going to be one mortgage or one IRA account, one account somewhere where a relative is going to need what's called a letters testamentary. How do they do that? Well, honestly, the courts will require a filing fee. In New Jersey, the filing fee is somewhere between $600 and $800 or $900, depending on the exact documents that you need. In New York, the filing fee is usually around $1,250. It's a little bit less if your assets are less than $250,000. But if you're above that mark, you better believe it's going to be $1,250, because anything over, actually, I'm wrong. The number is 500,000 in New York. Anything above 500,000, the number will be $1,250. and your relative will have to pay that before the case can proceed. It's not that the court will take the money after the case is settled, it's before the case can proceed. Now, 500,000 might seem like a lot, but if you have a 401k and you have an apartment, you've already reached that in New York. You can imagine that you're already there. So AARP estimates that the cost of probate is anywhere from 5 to 20% of the estate. So easily you're looking at fees of over $100,000 for the attorneys, for an accountant to come in and write up all the reports and do a proper inventory of the estate, and any kind of appraisals or auctions or what have you. The fees add up very quickly. You've got to get waivers from every person who could possibly inherit under the will, even if you explicitly disinherited them. So now another tough thing about filing a matter for probate is that they are public. So if you would like to keep your business private, you need to find another plan other than probate for keeping your business private. So all of that may have been a review for you. I'd like to transition now to compare the documents. How is it that the will, the power of attorney, the healthcare proxy, and the living will, those documents, how do they compare to the real kinds of planning that I'm talking about? Well, a key part of understanding is understanding what kind of power of attorney you have. You might say, wait a second, you mean there are different kinds of powers of attorney? Most people, when they get a power of attorney, they're writing a blank check. Now, I don't know how much longer I can use that as an example, because a lot of people under age 30 have never written a check in their lifetimes, but perhaps you understand. Writing a blank check is what most people have in a power of attorney. That means that the power of attorney can have access to the checking account, the real estate, the car, the brokerage account, any kind of pension account. Now, you might say, well, wait a second, I think I did something else. I went to this webinar and I checked a box. You may have checked the box for gifting. So you've allowed that power of attorney the ability to sell your assets, gift them, or to exchange them for cash, liquidate them. And in that case, you've given them a super blank check. Here's where that's a problem. Suppose you're in a hospital and the doctor comes in and says, you need to go to a skilled nursing facility and you need somebody else to manage your affairs. Well, what could happen is while you're in the hospital, that power of attorney with the super blank check, thinking that, oh, well, you're headed off to a nursing home and you've got to get some cash together, they might sell your assets right then. And you've already given them permission to do so. And then it turns out, either for whatever reason, there's not a bed available, or there's some other reason why you need to go back home, but your home has been sold. And you gave your super blank check to your power of attorney to make that happen. You need a plan. You need to not only give those powers, but also give instructions for how and when you want those powers to be used. So in most cases, I mentioned this before, families don't argue about care while their mother or uncle or grandmother's alive. Families don't argue about money when their relative is alive. They argue about care. So how do we turn all of this into real planning? We talk about the non-end of life issues, like the number of days you want to be sustained on life support. Did your healthcare proxy give permission for extraordinary care? Now, let me talk a little bit about that in the age of COVID. A lot of people's documents said no mechanical ventilation or no artificial ventilation. Well, we saw a lot of people get COVID and have to go on a ventilator. A lot of people died, but a lot of people went home from the hospital after being on a ventilator. We want to make sure that your documents can support that choice and support that decision. The other phrase that could get tricky is no extraordinary care. Well, define that in the age of COVID. Think about some of the famous people who have had multiple experimental drugs, very powerful drugs given to them, and it either shortened the amount of time that they had COVID or it actually saved their lives. So We want to make sure that there isn't a phrase like that in your documents that would prevent you from getting the care that you need. We do that by making sure that we not only make a plan, but that we have a chance to follow up and maintain that plan year after year as things change and as things develop. One more thing, a lot of documents said that the healthcare proxy had to see you in person to make choices. Well, there was a time when nobody was getting in the hospital to see anybody. So you need to write your document so that there's an ability to have a video conference or an ability to confer with a physician over the phone to make those determinations. So make sure that your documents stay relevant to what's going on in the world at the time. Let's talk a little bit about predators. That word might jolt you. You might say, predators, come on. Now, I probably don't need to do too much convincing to say that the government could be a predator. That would be through taxes. Now, a lot of people worry about estate taxes. Honestly, at this time, the Biden administration has not yet undone some of the changes that were done in the prior administration. So the estate tax really doesn't kick in at the federal level until you've hit $11 million. Now, it will vary from state to state, but $11 million is the IRS level. And most people are not going to be impacted by that. A few people will, and we can make plans for that. For purposes of this discussion, I'm going to focus on those who are in the below $11 million mark. So what about this second major predator? Long-term care. Now get ready for some big numbers. Long-term care. In the New York and New Jersey area, you're looking at a nursing home running somewhere between $10,877 a month to $13,407 a month. It's a lot of money every single month. Assisted living, $8,000 a month, give or take, depends on the area. Obviously more expensive in the city or on Long Island than it would be in like New Jersey or upstate New York. To stay at home, you know, to have a nursing program come in or a home health aide come in and do some chores around the house could run anywhere from $500 a month to $18,000 a month. So it really does require some planning. You don't have to like it, but this is one of those things that you have to accept. So could Medicaid pay for it? What are the rules for Medicaid? Let's take a look. Have you heard of any of these things? They could take your home. If you have a pension, just forget it. You have to give your assets away to protect them. If you give your assets away, you have to wait 60 months to qualify. None of this is true. None of this is a hard and fast rule. Here's what Medicaid is. Medicaid is a complicated set of rules, policies, some of them not even actually laws, but just policies in a region. And there are exceptions. So you have to know the rules and you have to know the exceptions. We also want to show you your options. Before I get into the options, sorry, I got sidetracked. Your greatest predator, I'm back to that word predator. Your greatest predator is unintended or unanticipated, and that could be your spouse. Why do I say that? Single people, indulge me for a moment because you're going to catch a break in this regard. Married people, what about if your spouse survives you? Then those assets that you've saved all of your life will then go to your spouse. But now what if your spouse needs nursing home care? Then your spouse may drain those assets and then they wouldn't go to your other beneficiaries, your children, your nieces, and your nephews. What about a remarriage after you're gone? Did you know that you can write a plan to protect your spouse who inherits from you so that if they go through a second marriage and that marriage doesn't work out, they can still retain their assets, and so can your children, protecting from that second spouse. You might say, don't worry, I know her, she's going to act sensibly, but things happen, things happen. So set that question aside. Suppose your surviving spouse never remarries. She remains faithful to you for decades. She builds monuments to you and shrines to you and talks glowingly of you for years on end. But then One day she goes into a nursing home, all of that money would go to her care. She didn't mean for that to happen, but that's what happened. Know your options. Oh, I wanted to go back. Suppose I kind of got sidetracked, excuse me. Suppose you have a niece or a nephew that you wanted to help out and you wanted to gift to upon your death. Now, let's think through that. Did you ever have a kid that you could give a nickel to and they would spend a dime? They could even go online and spend a dime, but you had only given them a nickel. What's going to happen if you give them tens of thousands of dollars? What about if they get married and that spouse of that kid then starts to encroach upon the funds that you really meant for the kid, or they divorce and she wants to take all the money? What about the beneficiary who's prone to addictions? That could be a real trigger, even if they're in recovery. What about the kid who's driven multiple businesses into bankruptcy? Gosh, you love that kid, but gosh, that kid is terrible in business. It happens. You want to protect them. What about a beneficiary who's disabled? Now you might be thinking, we're blessed. We don't have any of that in our family. But you know what? The week after you die, somebody could get into a terrible, terrible car accident, and they might need the services that the county or the community provides in the event of disability. But if they have inherited from you, they won't be able to get that care because they will have this nest egg that was a direct distribution. We want to avoid that. We want them to get the care that they need. Here's a big one, college financial aid. How many people do I talk to who say, oh, I really want to provide for so-and-so's college? Well, here's what happens if you make a direct gift to provide for college tuition. The colleges will look at that direct gift and say, you don't need any help from us. No scholarships for you. You're going to have to spend down all of that money before you qualify for any help from the college. So what you want to do is set that up so that they can get the college financial aid and then have benefit of the gift from you to use later on to make a down payment on a house, or to set up a business when they're done, to go to grad school, or to start off their own nest egg as they start their early career. One final thing, lawsuits. You can be sued. A beneficiary could be sued. A spouse of a beneficiary could be sued. And then your money that you've worked so hard for goes to settle some lawsuit that you may not even know the people involved. So all this doom and gloom, that's what lawyers do. It's just to shed light on what could go wrong, which what we're talking about is the proverbial rest of the story, the sad things that happen when people have a collection of documents, but they don't have a real plan to protect their loved ones. So we're back to know your options. I told you I'd get there. We're up to step 3, you'll be glad to know your options. We have a few different options. When it comes to estate planning, you need to understand 3 core elements. Who's in control? Who gets to benefit? And when? What is the timing on this control and this benefit that people are getting? So I'm going to go through some examples. Example 1, I'm alive and well. Things are going great. That's the when. Who's in control? I am. It's my stuff. I get to decide how it's going to be spent, who I get to give it away to. I'm in control. But example 2, I'm alive, but I'm not so well. My power of attorney has stepped in. Who's in control of the benefits? Well, actually, if I haven't written in any instructions or any rules, my power of attorney gets to decide who benefits, including, do I get to benefit from my own money, or does it get just given away? Remember, a plain old vanilla power of attorney doesn't come with instructions. That's what we want to get you to write in. I just hope that they'll spend that money on your care and not be a spendthrift. Now, step 3, I'm dead. Now who controls my stuff? Well, if it was just a will, I'm in probate, my estate is in probate, and then the court is in control. Do I have a beneficiary designation for all my stuff? Great, give it to the beneficiaries. And if you've done that, you will avoid probate for almost all of those accounts. That it will go very seamlessly. But here's the thing. Suppose you gave all of that money over as a direct gift. it's not protected, even an IRA. And according to a Supreme Court 2014 case, the protection, the retirement account protection does not extend to the next generation. So when it's handed over to your daughter or your nephew, it no longer has those protections from creditors that retirement funds have. So you might have heard this expression, I don't want to control from the grave. I can understand that. Maybe you don't want to control from the grave, but you do want to protect from the grave. And you have the ability to do that if you can write your plan with your set of rules. Typical goals of an estate plan. These are the goals that most people that I talk to will say. They say, I want to stay in control. It's very important to people. They don't want to become a burden to their loved ones, and they want to keep it simple. Now, in layman's terms, when a layman tells, or when a client tells an attorney, I want to keep it simple, what they really mean is they don't want to spend a lot of money. Given a choice between a basic will plan and a trust, or an asset protection trust, or a Medicaid trust, they say, oh, I want to keep it simple. Well, what that really means is you're going to defer that expense to your relatives, and you're going to make your relatives then pay the cost of all of this kind of plan or cleanup from what you could have done right now. So they'll have to pay the probate attorney and the filing fees and all of the others. So our goals for your plan, we want you to know the difference between documents and planning. We want you to understand all of the costs, including the costs that you pass along to your loved ones. We want you to know your options and help you to choose the right plan for you. Now, we saw this before. Here's option one. The government does have a plan. We're going to move on. I think you know that one. Protect from long-term care costs. We want to minimize costs and afford the care that you deserve. Now, let's look at this, because with the right plan, you can protect your assets and still pass along assets to the next generation. Most people don't wake up and say, wow, that nursing home, gosh, it looks good. I want to live there. I want to move out of my home that I've lived in for decades. I want to go down the highway to that nursing home. It really doesn't happen that way, does it? You know it and I know it. Most people go from a hospital bed to a rehab or skilled nursing facility to a nursing home for long-term care because they can no longer get the care that they need at home. They might choose to go to assisted living. That's an option, but at some point, even the assisted living center is not going to accept you if you need a high level of care. Long-term care insurance is an option, and I do still see clients with very rich policies that they bought in the 1990s, the last century, or maybe at the very beginning of the 2000s. There were some really very abundant long-term care policies, but they're expensive. Those premiums are $850 to $1,000 a month or even more. And that's if you can qualify for them now. If you have any kind of health issue right now, you probably won't qualify. There are waiting periods. And honestly, if you're going to be paying for those premiums, you're actually taking money out of the resources that could be available for your family, either for your care or for later on. I'm going to talk for a little bit about Medicaid, and I'm going to give a couple of scenarios. So here we go. There are times when we talk about Medicaid, two times. One is crisis planning, one is pre-planning. So the next two stories are based on real people. We're going to talk about Mary Smith and her mother. Mary Smith called a lawyer friend of mine, actually a lawyer in Lawyers with Purpose. She said, my mom fell and she's been in the hospital, and we were just told that she won't be able to come home. My dad can't care for her. She can't get the care she needs. She needs a very high level of care. So she has to go to the nursing home. So I happened to run into my lawyer that did the closing on my house. Remember, I bought a house 2 years ago, and I ran it all by him, and he was very clear. We've got to spend down everything as fast as we can because we're going to be paying out of pocket for 60 months. So that's what we're going to do. So they talked about the situation. Mr. and Mrs. Smith had a very modest house for 60, that had $60,000 of equity in the house. They had a car worth $10,000, cash of $105,000, and investments of $275,000. So you see, these are not people that were destitute. They had cash, they had stock and investments. Right off the bat, unlike what the real estate attorney had said, he probably knows real estate very well, but he doesn't know estate planning. Right off the bat, we knew that the house was exempt because the spouse could live there. So again, single people, and unfortunately, even widowed people. Widowed people, I'm very sorry for your loss. And I'm also very sorry that that's going to move you into a different planning category for this type of asset planning. So single people or widowed people, we're going to set things up differently for you, because once you go into Medicaid, the government will then put a lien. They will accrue a lien every month that you need care. And so we set things up differently in your situation. But married people, if you have a spouse, the spouse can remain in the home and it's exempt. Don't let anybody talk to you about a Medicaid divorce. I think every week, or maybe even more often, I'll hear, oh, well, you know, they had to get a divorce, or they had to retitle everything to put in her name so that he could go in the nursing home. That doesn't work. It doesn't work. It goes right back to that thing where the lien is accruing against the house. So now, what about the car? Well, Mary's dad could have use of the car. The $105,000 in cash, well, right away we could exempt $74,820. That's a big chunk of it. The rest of it that we weren't able to exempt, we were able to judiciously apply to things that Mr. and Mrs. Smith had been putting off because they wanted to preserve their assets. So the house needed a heating system. They had been putting it off for years. They got it. The house needed a new roof. They had been putting it off because they wanted to save money. They finally got it. And those were exempt expenditures. Those were things that were okay to spend the money on and not impact any of the spend down or countable assets is what we really look for. So what about the $275,000? Well, in this scenario, we were able to talk about that. And, you know, the real estate lawyer had said all of that needs to go. You've got to spend it down because it's going to go to the nursing home anyway. Well, now think about that. If a nursing home is $12,000 a month times 60 months, you see where that money went. And that is the real heartache of this dilemma for families. Mary's family, with all this money, could not afford to have her mom in a nursing home. And yet with this savings that they had scrimped and saved for all of their life, they didn't qualify for Medicaid without the extra planning. So you'll be amazed to know they were able to protect $275,000, and in a crisis situation, they immediately qualified Mary's mother for Medicaid. They didn't have to spend down any of these assets. They were able to preserve them for Mary's father and for the children and grandchildren. Good story, right? Now, what if you need to plan now? Meet Mr. and Mrs. Richards. They were 75 years old, and these are real people. They went to a colleague friend of mine in Lawyers with Purpose. They actually said, you know, we're not really worried about the 5-year spend down because we're 75. We don't think we're going to live to be 80. They had $577,000 in assets. We weren't able to exempt everything right off the bat. We were able to exempt with a plan $128,000 over time at a rate of $3,459 per month. Now, I didn't just make up that number. The Medicaid rule book told me how much could be exempted each month until we finally got it at 37 months, not at 60 months. At 37 months, we were able to get it so the entire portfolio of $577,000 was protected. Now, you will have a certain amount of money that will be at risk to lawsuits, creditors, predators. You will have a certain amount that we can protect right away, immediately. Another part that we're going to put in this gradual protection over time, over however many months, whether it's 24 months or whether it's 45 months, and eventually we'll get it so your assets are protected. Don't get caught up in the numbers for either the Richards or for Mary's mom and dad. Don't get caught up in the numbers. What we're going to do is look at your numbers. I want you to get the concepts. We have a certain amount we can protect right away. We're going to protect the rest over time until a point where we've got your whole portfolio protected and you qualify for Medicaid. Now, how do we do this? How do we protect your trust? To a lot of people, if I say trust, they have a picture in their minds. They know of somebody who had a trust. A lot of times they think, oh, well, that person had a ton of money. And then or else we hear it kind of in a bad context. Well, you know, that kid has a trust fund. It's a trust fund kid. I'll bet everybody watching this has some idea of a trust that they can bring to mind. Here's the idea I'd like to put in your head, that little red wagon. Think of a trust as that little red wagon that went with you wherever you went. You got to decide what went in it, and you got to decide who could take the handle and drive that little red wagon or pull that little red wagon around. It's going to be the same with your trust. Many of you have heard of a testamentary trust. That simply is what, you know, upon your death, my last will and testament, I set up this trust. Now that's great. It does accomplish the goal of avoiding probate. What it doesn't do is it doesn't pay for your health care. It doesn't cover your nursing home cost, doesn't carry the cost of nursing care in your home. It's great for your beneficiaries. It avoids probate, but it doesn't do a thing for you. So let's skip that one. A living trust, RLTs, revocable living trusts. You see that opening at the top of the box on the RLT? That's the huge downside. Now, all of your stuff that's in there is protected from probate, and it's a very convenient thing for your beneficiaries, but any kind of nursing home or any creditor, any predator can reach right into that RLT and take those assets. There's a very important concept to talk to you about, and it's this: I must give up my rights to that which I would like to protect. I'll say it again with slightly different words. I must give up my rights to that which I wish to protect. That's our guiding thought in setting up these trusts. You see here on the screen, IRR, irrevocable trusts. Now that IRR tax, that's for that high tax bracket. That's for that 11 million plus. I'm not going to really even go into that in this seminar. I'd like to focus on the IRR AP. You see the hinged box? It's really going to own, if it's built in any way, set up in any way that you are able to serve as trustee, it's not going to give you the protection that you need, and the creditors and predators can still reach right in where that box is open. What we really want is some kind of an asset protection, that's that AP, that will give out enough money for you to have the healthcare and the income that you need, but still protect the assets for the next generation. The bank account, you can move it around. You can get the interest from it for income, but you can't put it in your name. It's in the trust's name. Same thing with the brokerage account. You can spend all day, every day planning the investment strategy, but that brokerage account cannot be in your name. It needs to be titled in the name of the irrevocable trust, in the Paula Collins Irrevocable Trust. And that way you can have access to the income, you just can't have access to the principal. Now you can gain access through the trustee, but you can't have it directly. So you say, there are different kinds of trusts, but how do I make them work for my situation? How do I create my rule book with my voice and with my plan that actually works? Let's hark back to the topic of care. The generic trust that most lawyers will set up And frankly, that you could go on LegalZoom right now and set up. You could get your trust done this afternoon, just clicking around on LegalZoom, pull out your credit card, you're all done. But that generic trust, and frankly, what most lawyers will set up, calls for a 2-doctor competency. Well, let's get again back to the age of COVID. Have you tried to call a doctor? Good luck. Keep dialing. You could go several days, several weeks without being able to reach a doctor. It's just the unfortunate reality right now. If we write your plan so that we get around that 2-doctor competency, it's not something that's required by the law. We can write your plan so that a trusted circle of friends or 2 friends will be the people who determine your competency. Most trusts make a distribution on death. We set up to protect your money for your loved ones so that the protection of that asset continues in the form of another trust. So it goes from this trust to another trust, rather than just making an outright distribution. Let's talk about your IRA. I mentioned that before. We want to continue those protections so that the funds are still safe from the next generation's creditors and predators. I know you're getting antsy. I'm going to tell you 4 stories in quick succession. Are you ready? Let's take a couple. I'm going to make up some names. Adam and Beth, nice couple. A, B, Adam and Beth. They have 2 kids, Cindy and Diane. So now I've got A, B, C, D. Now, single people still listen to this, even though I'm describing a married couple, because a lot of this will still apply to you. We'll tweak it to your situation. But the other thing is, this couple, as long as they're legally married, it could be Adam and Bob. It could be Ann and Beth. It could be Beth is the one that's the big money earner and Adam is a stay-at-home dad. So any kind of configuration, bear with me. Let's go through these scenarios. I tell you there are 4 scenarios, and then unfortunately there are 2 more. So bear with me. We're going to get through this. The couple have $2. It could be $2. It could be $2 million, whatever. Don't get tied up in the numbers, just do the concept. So $2. Adam and Beth can do anything they want with their $2. They can spend it, they can invest it, they can give it to their kids, they can set it aside to grow. But what do they decide to do? The first thing they do to protect from creditors and predators is they create a trust. And now Adam has $1 that's protected, and Beth has $1 that's protected. So now Adam gets sick and he dies. Tragic. Where does his $1 go? It goes to Beth. So now she can save it, spend it, invest it. But wait a second, if he made a direct gift to Beth, it's just as vulnerable as if there were never a trust in the first place. So instead of giving it directly to her, he creates another trust upon his death. And that way, there's an irrevocable trust for the benefit and for the benefit of Beth and for the benefit of the children. All that they need to do is ask the trustee for money, and it can be given to them as long as it's okay with the trustee and it's according to the rules that Adam had set up. So that's as long as we don't make Beth the only trustee. Okay. If we make Beth the trustee, it means that she can get to the money, and we don't want to do that. So when Adam sets up the trust, he makes Beth a co-trustee along with Cindy. So Cindy is a co-trustee, Beth is a co-trustee. Now, Adam's money is in the closed box, but Beth's money is still in the open box. So Beth can do whatever she wants with her money. A year later, Beth calls Cindy and says, you know what, honey, I need $10,000 of the trust in order to redo the floors in the apartment. And Cindy says, what do you mean, Mom? What's wrong with the pink shag carpet that's in the living room? I've loved it all of these years. And Beth says, no, I really want a new carpet. And Beth says no. And so what does, or Cindy says no. And what does Beth say? Beth says 2 magical words. Well, she might have said 2 other words, but for this story, what Beth said was, you're fired. And Beth has that ability. According to the way that the trust was set up, Beth has the ability to fire the trustee. So that evening, Diane calls and she hears that Beth's kind of down and says, what's going on? And Beth says, I really want to redo the floors, but Cindy wouldn't give me the money. So now I don't know what to do. And Diane says, well, I'm so relieved to hear that you finally want to get rid of that pink shag carpet. And so Beth says, Diane, how would you like to be my new co-trustee? And just like that, Diane is designated the new co-trustee. Beth gets the funds that she needs. Everybody's happy. So now let's rewind. Let's go back to the $2. They set up the two trusts. Adam dies. And now instead of Beth wanting to replace the pink shag carpet, she wakes up one morning and her face is sagging and she's speaking gibberish. I think you know what I'm talking about. She had a stroke. The nursing home says, well, we see that you have this dollar sitting here in your account and we're going to take that. Thank you very much. It was set up for your care. And so now we're going to take it for your care. And now we're going to take a look at this money that your husband left you. And it's now grown to $3. And just as they're reaching out for it, Cindy and Diane, whoever's the trustee, says, oh no, that money is protected. And Beth, even though she's incapacitated, kind of giggles and says, my husband, he had all of these funny rules about how that money was to be spent. And it did not include being spent on a nursing home for me. They wrote the plan with the rules. The money was protected for Cindy and Diane. So you see, we can do a lot with these plans. Take 3, third scenario, the story of Adam and Beth. Beth doesn't need new floors. She doesn't need a nursing home. Instead, she gets into a car accident and she kills somebody. She gets sued. What happens to her dollar? Gone, unfortunately. What happens to Adam's dollar? Protected. Nothing. Because it's safe. It's there for Beth to use it for her care. And it's also there to pass along to Cindy and Diane. Take 4. Here's where it gets really interesting. Ooh. The story of Adam and Beth. Beth doesn't need new flooring. She doesn't have a stroke. She doesn't get sued. Instead, Beth, after Adam's death, gets very active in whale watching. She goes on trips, she watches whales, and lo and behold, she meets the very young and dashing Ernie. Ernie's 25 years younger, and he loves to watch whales. And so they rent a house, and for 2 weeks together in Cape Cod, they watch the whales. And pretty soon Beth calls Cindy and says, I need $10,000 to go with my new young friend Ernie to go watch whales. And Cindy says, oh no, Mom. You have your own money and you can use as much of that money as you want. It's there for you to enjoy. But Dad left money for you to use for repairs on the house and for your health care, and ultimately to pass along to Cindy, to me and my sister, to me and Diane. And so what does Beth say? She remembers those 2 words that worked so well before. She says, Cindy, you're fired. And Cindy says, oh no, Mom, read a little bit further. Because remember when you and Dad set this up, you wanted to protect each other. And so you wrote the rules that said that after you get remarried, you can no longer fire me anymore. And Beth says, I'm not getting remarried. I'm just going off with Ernie to have fun. I was married forever. Now I'm having fun. And Cindy replies, but you both wrote the rules and it defines remarriage as remarriage or cohabitation for one night. Now that might seem harsh, one night. It's your rule book. You could set it up for 1 month, 3 weeks, whatever you want to write, but protect that spouse from the thought of somebody else coming in on the scene and taking advantage of those assets. Why would they ever agree to such a thing in their trust plan? The reason is they both knew that a new love or even a new flirtation that comes along, something happens to clear thinking and to the best laid plans. They wanted to make sure that they could still financially prepare for each other's health care and well-being, as well as continue to care for their children, Cindy and Diane. So Beth was still able to have fun with her young friend Ernie and go off and whale watch, but with her money, not for the money that they had set aside specifically for healthcare and specifically to pass along to the next generation. So you make the rules, you make the rules work for your situation. Now, these are not the usual documents. If you sat down to any kind of an automated legal document planning, this is not what would be produced. You need to do this as a custom design that fits your situation. And then, as I say, revisit it each and every year. Okay, 2 more stories. This brings back the single people again. Come on back, single people. This applies to anybody. Beth is single because the law considers her single after Adam died. And now Beth dies. And what happens to the $2? A dollar goes to Cindy, a dollar goes to Diane, right? Assuming they had 2 kids. Wrong. Absolutely not. Don't make a direct gift. Put it in trusts. Don't give it to Cindy and Diane. Give it to the trust of Cindy and the trust of Diane. Remember, no direct gifts. So Cindy comes to Diane, they have the trusts. And Cindy says, you know, I'd really like 200,000 to buy a condo in Florida. And Diane says, why do you want me to give you 200,000 from the trust to buy a condo in Florida? Just let the trust buy the condo in Florida. Don't buy it directly from your money, buy it from the trust. And so Cindy and Diane, as trustees of Cindy's trust, go buy a condo in Florida. That way, Cindy and her partner of many years have this cool getaway. They love the beaches, they love the warm weather. Now, who owns Cindy's condo? Well, Cindy's trust does. Who pays for all the expenses on Cindy's condo? Cindy's trust does. Who gets to live in the condo in Florida? Cindy, not Diane. Because you see, Diane is only a trustee. She is not a beneficiary. So that shows you some of the limitations on what a trustee can do and can't do. The trust is set up for the benefit of Cindy. So now Cindy and her spouse, her close life partner of 30 years, they get into this nice routine of going down to Florida. And suddenly that partner says, you know, I now have such perspective on things. This has been great. I love playing golf. I love lazing around on the beach, and I am now out of here. I want you to sell everything and send my half to this PO box because I'm going off on a motorbike tour. It's not going to happen that way. Why? Because the trust owns it. Cindy doesn't really own it. There's no need for her to sell it and give 50% because guess what? She doesn't even own it. It's the trust that owns it. Adam and Beth loved their kids way too much to make a direct gift. Why would you ever give anything directly to somebody that you love? Now, did you ever think you would agree with me on that? You want to give your money and your stuff to a trust that they can control. They have the key, but not the spouse, not the new fling, not the government, not the lawsuits, not the nursing homes, not anyone. No one can take money from Cindy and Diane ever, unless Cindy and Diane take it out of that box. Once they take it out of that box or out of that little red wagon, then it could be taken. Understood? So we're not all set yet. We said getting your voice and what you want in there is the first part. The second part is getting all of those things into the wagon. We call that integration. That's where you're going to retitle things and put them into the little red wagon. What can happen is that people will get this trust document, and back to the document idea, and forget about the plan. So they might have the trust, but then they never bothered to retitle the house. They never bothered to retitle the brokerage account into the name of the trust of. And so then when they become incapacitated, their little red wagon is empty. And all of these things like the stocks and bonds or the bank or the brokerage account are still sitting outside of that little red wagon. So a very important part of this plan is actually integrating and retitling things. So you're not all set until you've put everything into the little red wagon. If I go down, I'm all set as long as I've got everything in that little red wagon. So I created my rule book. Am I set? I integrated it. Am I finally all set? Well, it depends. A lot of things can change. My family configuration could change. People die, people have children, people get married, people get divorced. My finances could change. The market could go way up or the market could go down. My health could change. And that's really what's the driver of a lot of this, or the law could change. The law could be revised. Remember, Medicare is a very complex set of policies, and it can vary from county to county and get interpreted differently from year to year. But I have to maintain it. Every single year, I've got to sit down and really review my documents with a professional. So let's wrap this up. Our goal of the workshop was to determine if you were all set. I suspect that some of you may have learned a thing or two. Some of you may be thinking, oh yeah, I've got that part, but maybe I need to ask about some other parts. The second thing was to help you understand what it takes to protect you and all your stuff. I hope that you've learned something there and had some fun along the way. We have to build a plan with your voice in it. You have to integrate it and you have to maintain it. So here's a list. Here's that list from the beginning. Haha, you probably thought that it was there for your benefit. It was actually there for mine. It helps me organize the PowerPoint, so I talk about the things that are important. I think we answered just about everything that's on there. If you're unclear about something, definitely reach out to me. Did I keep my promises? Did our time go by quickly? I hope so. Did you learn a lot? I hope so. Did we have some fun? Well, a little bit. I hope you like the whale watching story with Ernie. Please reach out via phone or email. My office will reach out to you. The way that we're going to proceed from here to identify what's missing, another 3 steps. Sorry, I'm really stuck on this 3 easy steps. You have to act. You have to assess your needs, create what's missing, and tie in your plan with your life. That's that integration piece. And our next step is to book a vision meeting. That's where we're going to review your stories, review the stories I've outlined, the Ernie story, you know, the whale watching, and really even going all the way back to Mr. and Mrs. Richards and what we could protect and what we had to like gradually protect along the way. Assess if you have all of the things that you need, and if so, how we could get, if not, how could we get them? And if so, mapping it out and communicating that plan. We're going to provide you your Medicaid numbers. I mapped out the Richards and their numbers. We're going to look at your numbers and see, well, how many months would it take for you to qualify for Medicaid? And do we want to get that in motion now so that if you were to get sick in 6 months, we would know how far are we away from getting you fully qualified? And then we want to tie it in. We want to provide the 3 options to create what's missing. In other words, we want to find those irrevocable trusts that will work for you. And then we want to tie in that plan for the rest of your life. Thank you so very much. I hope that you found this video helpful. Please share my contact information. Maybe as you were sitting here, you were thinking, I bet my sister-in-law could really benefit from that. Whoever, think of somebody and please share it with somebody else. There's my contact information, and I hope you have a good rest of the day. Thank you.